to Lawminds, where we talk about different case studies and give a in-depth article on various legal topics. In today's video, which is presented by monsij chakraborty, our topic for today is embracing the power of volenti non-fit injuria. Introduction. Welcome to the world of volenti non-fit injuria. This presentation will take you on a journey to explore the unconventional forces of consent. Get ready to unleash your creativity and embrace the power of consent like never before. Understanding volenti not fit injuria. What does volenti non fit injuria means? It is a legal maxim that translates to a willing person no injury is done in the law of torts. If any person commits any sort of wrongful act which causes some injury to another person, he is held liable and has to pay damages or provide some other remedy which the court determines as fit to the victim of such an act. But in some cases, even if a person suffers from losses because of the act of another person, he cannot claim damages from that person because of the operation of defenses of torts. One such defense available to the defendant in the defense of volenti non fit injuria, in which the plaintiff is not entitled to damages because he consents to the act which has caused injury to him. Elements of volenti non fit injuria. Now, I mind you, friends, the elements are a very crucial topic of this part. For the application of the defense of volenti non fit injuria, there are some essential elements or conditions which should be present in a case, and only when they are fulfilled these defenses can be taken to prevent liability. There are two essential elements in this defense. The plaintiff has the knowledge of the risk. The plaintiff, with the knowledge of risk, has voluntarily agreed to suffer the harm. Thus, whenever the plaintiff is aware of the possibility of harm which is likely to be caused by an act, and when he still accepts to do that act and therefore agrees to suffer the injury, a defendant is liable of his liability. But only having knowledge about the risk is not enough for the application of this defense. It is known as scienti non fit injuria, which means that mere knowledge does not consent to the risk. Thus, having knowledge is only a partial fulfillment of the conditions of the application of volenti non fit injuria. Illustration. If A has a bike whose brakes do not work and B, knowingly about the conditions of the bike, still chooses to sit on it with A driving it, and due to the failure of such brakes, they both sustain injury in an accident. B cannot claim relief from A because he had voluntarily consented to sit on the bike. But in the above case, if B was not aware of the condition of brakes and he sustained injury sitting on it, he would not be stopped from claiming damages from A because here B did not give his consent to accept the risk of getting injured due to failure of the brakes. Consent as a catalyst for innovation. Explore more consent can be powerful catalyst for innovation by embracing diverse perspective and encouraging open communication. We can unlock new possibility and drive creative solutions. Let's harness the unconventional forces of consent to spark innovation in every aspect of our lives. Navigating consent in a changing world. In a rapid evolving world, Understanding and navigating consent is very crucial. Learn how to adapt the changing dynamics and foster a culture of respect and consent. Discover practical strategies and tools to ensure that the consent becomes an integral part of our personal and professional responsibilities and relationships. Embracing consent, breaking boundaries. Break free from traditional boundaries and embrace the power of consent. Explore how consent can transcend societal norms and power individuals to set their own limits. Unleash your creativity and challenges the status quo by embracing the unconventional forces of consent. Conclusion. Volenti non fit injuria is one of the defense under the law of torts in which the person who has committed a wrong is exempted from liability because the victim of such a wrong gives his consent to the commission of such an act, and such a consent must be free from the successful application of this defense in a case. This defense is only subject to certain limitations, such as rescue cases and the negligence of the defendant, in which, even if the consent is given by the plaintiff, the defendant is held liable. Thus, while allowing this defense, court have to ensure that the condition of this are taken care of. Thank you on behalf of Lawminds. If you have any questions, then do comment below. And if you want to reach out to Lawminds, then we have provided you the email and the contact details. If you like this video, then please give it a thumbs up. Follow us on our Facebook and Instagram pages. Thank you.